program is rated GE. Content carried in here is suitable for general family viewing.
It is August the 30th, weeks after the August 9th general election, and the country finds itself in yet a familiar situation of a presidential petition. Azimio la Umoja One Kenya, alongside 7 other petitioners, have filed a petition seeking to invalidate the victory of UDA presidential candidate William Ruto as the president-elect. But before we look into what is happening in the country right now, we want to contextualize what is happening by looking at the journey we have come as a country. Join me on Legal Matters, a show that is educative, informative, and provide legal solutions to issues that we face day-to-day on our day-to-day life through Legal Aid Clinic here at KUTV Kenya Live at Kenyatta University School of Law here at Parklands. You can interact with us by sharing your comments, opinion, and questions at KUTV Kenya on YouTube, KUTV Kenya on Facebook, and KUTV_Kenya on Twitter. My name is Irene Mwangi. I'll be your host, standing in for Dr. Ngugi King'ara. Now, it is 8 days of the petition of the 2022 presidential petition, and as a country, we have come a long way to the extent that any party that is aggrieved when it comes to election can feel comfortable in filing a petition at the Supreme Court. But before I get into the nitty-gritties of what is happening in the country and election petitions, I will start by introducing my guest from my left.
Thank you once more for welcoming me. My name is Jackson Lungu. I'm an advocate of the High Court of Kenya. Thank you.
Welcome.
Thank you. My name is Alice Mongare. I'm an advocate of the High Court of Kenya, a lecturer at the Kenya School of Law. I teach civil litigation, and at KU Parklands, where we are tonight.
Right. Yeah, many thanks indeed for actually making time for this particular discussion. Now, where we are as a country, and beginning tomorrow will be the start of a hearing at the Supreme Court, and it will be expected to be a buzz of activities. But what most people don't know is that for us to get where we are, it has been a journey. Advocate Alice, can you kindly tell us what is election petition and the far that you have come to the extent that we are now?
Thank you very much. Just like the term goes, petition, it means to question, to challenge something. And in this case, when we talk about election petition, specifically we are challenging, we are questioning the president-elects. We want to question whether, we want the court to determine, was that election fair?
Yeah.
Was it credible? Was it transparent? That is what we'll be looking at.
Right.
Yeah.
And still on that, so that we can start the conversation. When it comes to petitions, most people have thought that petitions were filed in 1997, and then we had 2013, 2017, and now we are talking about 2022. When Kenya was a one-party state, did we have petitions being filed at the court at the time?
We have come a long way. After independence, after the colonialists left, we had the Kenyatta One regime.
Right.
And during that time, we had a de facto kind of system in this country, whereby there was only one party, and of course we had elections, but the rules that were there the environment did not allow democratic space. We had the Electoral Commission of Kenya manning elections then, and this went on to the Moi regime. The Electoral Commission of Kenya was manning elections, and you could only join the Electoral Commission of Kenya if you were in good books with the president then. And you could only be assured of victory if you were again in the right books. And even the systems that were there during the Moi time and even the other time, one of them, I could cite the Mlolongo system.
Yeah, I remember it.
Where people used to queue behind a candidate that is their own, that is their preferred candidate. And so many irregularities, so many illegalities were being committed then. Chiefs were employed and village elders, they used to make sure that people stand behind the preferred candidate of the then president. And if in any case you managed to win, if you had loans, they could secretly go and pull the string so that you find the banks following you. Even if you did not win, of course you couldn't win. They pull a string and you become bankrupt. There were tribal clashes that were started where it was thought to be a stronghold of a given candidate that was not the favorite of the then president. So we could have tribal clashes, the Molo clashes, the wards all over the country, so that these people run away. They cannot vote when they are
fear.
Due to fear. Yes, so that is the kind of climate that was there. Yes.
All right. So when you talk about that and how fear was instigated at that particular time, did we have heroes or people who stood out to file petitions all the same?
That was in 1992 when we see people filing petitions. There were 6 petitions that were filed then, and one of them was for Matiba. Matiba had really suffered. He had been tortured. He had gone through a lot, and he developed a stroke. His right hand could not, he was right-handed. He couldn't sign a petition. What I forgot to tell you is that there are several ways that you move to court. But when you are challenging an election, you do it by way of petition. And the rules of making the petition is that the petitioner is supposed to sign that petition. And so he took a turn in civil litigation. He donated powers of attorney to the wife then. And the wife was signed the petition, which is allowed in law. It is provided for under the Civil Procedure Act and the Civil Procedure Rules. You can donate specific powers or general powers. So he gave specific powers for purposes of this petition.
All right.
Little did he know that President Moi then, the late, proceeded to court through his lawyers and on a technicality challenge this, that he did not sign that petition himself, yet that was law, going against the many laws that we're going to learn today.
Yeah.
So, and that was the end of that journey.
All right, Advocate Lungwe, looking into the likes of Matiba and those who came out during the one-party state to sort of seek to challenge presidential election, from where you sit and when you look into the laws that were there at that particular time, was it a lost cause, or it was just the beginning of championing for rights when it comes to electoral justice?
Yes, and I'm happy you have used the right word, electoral justice. That is the actual word to be used in that context. I can say that it wasn't a lost cause because it was a beginning of better things to come. For example, what we're experiencing right now is something that we need to celebrate.
Yeah.
You see, having the space the freedom and the right to challenge the president of whoever has been elected as the president, regardless of the outcome.
Yeah.
That is one vivid demonstration that we have made tremendous improvement in terms of pursuit of electoral justice. And I really appreciate what my senior and my lecturer has said, because she taught me as well,
Interesting.
that she has laid a very good foundation for us to understand the context under which these things are happening. So that when you see, for example, previously 2017, you saw the elections that were big, or rather the election outcome that was being challenged was the one of the incumbent president. You see, right now you can see the playing field is more of balanced, because the president-elect is not the sitting president.
Yes.
But in 2017, I think the example was so vivid to the extent that people could see that the person whose victory is being challenged is the person who is still the commander-in-chief.
Yeah.
You see. And if you were to look back, to flash baback and, for example, compare 1992 and 1997, you realize by then that space wasn't there.
Yeah.
The then President Moi, given his style of rulership, if I may call it so, coupled with the laws that were in place, altogether could not afford or create such an environment where somebody who is in opposition could stand up and say, I'm challenging the victory of president-elect.
Right.
But right now, what we are witnessing here is a vivid demonstration that we have made tremendous improvement in terms of our democratic space, in terms of the journey to realize electoral justice, and even in terms of constitutional and legal infrastructure like judiciary.
Right.
Because one thing that people also blame is, you see, people blame, for example, judiciary by then, or the petition of Matiba was struck out on a technicality. But a lot of people do not take the trouble to understand the environment under which judges were operating. Our judiciary. You realize that our judiciary had been greatly stifled, and there was no, this now what we call the independence of the judiciary wasn't there. So most of the judges, they had either you toe the line or you are thrown out.
Yeah,
and that was the problem that we were in.
And that's why I want to bring the discussion into, we fast forward to 1997. Again, we see Matiba. This time we see Raila Odinga using NDP. And Mwai Kibaki was also in the picture. In 1997, was there progress in terms of seeking electoral justice, or were they stuck in the Moi regime, given that after 1992 we had multi-party? So was that a progress in terms of seeking electoral justice at that particular year of elections?
Thank you. I think I can take that. After 1992, in 1993, Parliament voted to change the laws so that we could experience a different way of democracy. And in the year 2002, everybody was up in arms. They wanted Moi out. And that was the agenda. And so they came up with a law and said, now Moi should not even vie. They came up with 2 terms. 2 terms started being championed in 2002. But then we see Orengo going to court and challenging the election of Moi. But again, it was thrown out on grounds that laws could not move retrogressively. We had to move progressively. And so in 2007, that is when we still had, can I say, we were still enjoying, not really enjoying.
But feeling the freedom from the Kanu regime? Yes,
but we were not really free. The elections were not really free. We still had the Electoral Commission of Kenya, and it is the president that was choosing those people, like we said. And so something really bad happened that time in 2007. That was a turning point to where we are today. Kibaki was elected. The methodology, the processes that were being done then was that the ballot papers were being ferried from different polling stations to the tallying center using, manual methods, as opposed to what is happening currently. And so there was, people really felt like Raila Odinga won the election then. But then Kivuitu then just announced, lights went off, there was a blackout, and Mwai Kibaki was announced as president-elect, and that is how everything went on.
All right, and I want to get to you, Advocate Lungwe, just before we take a break. Between 1997 and 2007, there were 10 years, but still there was not independence of the courts at the time, and there were not electoral laws to ensure transparency in elections. Why did we take such a long time to stay woke in terms of ensuring there's transparency in how we conduct elections and even seeking electoral justice?
Yeah, you see, and as my seniors explained, after 1997, there was an improvement, yes, but it wasn't enough to guarantee electoral justice. Coming to 2002, the biggest, we consider as a country, the biggest monster was KANU. Let's get KANU out of power. So everybody concentrated on getting KANU out of power, as opposed to thinking hard on how do we put institutions and infrastructure and law in place to guarantee some of the things that we are fighting for.
Right.
So in 2002, yes, we succeeded to eject KANU from power, which was considered to be an evil regime, and get in NAC. But remember, nothing had really happened in terms of changes in our laws and in
systems.
So in as much as Honorable Kibaki and his regime was much, much better, the NAC regime was much better and an improvement of KANU, but we didn't have the system to sustain it.
Right.
We didn't have the adequate laws. And that's why when we tipped in 2007, now we find ourselves in trouble because there is no system. Judiciary is still the same and reformed. There is no, for example, clear constitutional structure and legal dispensation on how you need to prosecute the aspect of election petitions and to pursue justice. There was none. So we find ourselves in that situation, and that's why immediately after that, after the violence which had erupted and the destruction and death, we realized no. We can, in as much as we have regime changes, we need to have a structure, and the only way to have structure is to have to change the bedrock of our legal system, which is now the constitution. That's how now we put in the new constitution, new judiciary, which was reformed, new institutions like the Supreme Court. Now all these institutions come into play, and it is at that point when we were able to realize some significant changes.
All right, thank you, Advocate Lungwe. And now we'll have to take a short break, but when we'll come back, we'll be looking at the structures, the law, the constitution, the 2010 constitution, and how far it has helped us as a country to put structures in terms of seeking electoral justice here in Kenya at a time where we are facing a presidential petition yet again. Stay with us.
In life, we get to celebrate so many special occasions, personal occasions, friends occasions. We have birthdays, weddings, we have anniversaries. And for us to do all this, we need to have cameras, and cameras are operated by photographers. What's the advice you'd give to that young person who has a dream to be a very good photographer out there?
To photographers, probably, I would really want them to be a bit more united. Other places, you know, when photographers are more united, they're able to create a new craft, a new style to.
Natoka ile mtenye Maslay Queen utembea na visi ndio nikawa tamada vijana. Akajiona mdeadly kushinda waganga wote wa Kitui. Hakujua hii kitu hii ni tricky.
Imekuwa chai. Ite kitu kidogo just to get in between my thighs at I love you.
today I am at Jua e-bikes.
So if you look at our bike, it's quite competitive compared to Boda Boda, which is currently used especially for delivery riders. This is because unlike a motorbike, you don't have to use fuel. So you basically need to use 12 shillings just to charge the full battery to operate within a day.
This is the battery. Every battery has its own key. So you put it in, you unlock. So you get it out. You can take it back in. Okay, you get it out for the purpose, the charging purpose. This is increasing the speed, reducing the speed.
Welcome back. This is Law Matters, a show that is educative, informative, and talks about the issues of law by offering legal aid clinic. We're talking about election petitions. And before we went to a break, we're speaking about the issue of the 2010 Constitution, how that particular Constitution has helped us create structures. With me is Advocate Alice and Advocate Lungwe, creating a context of what we are facing us as a nation during this particular time where we're having the 2022 presidential petition. Now, Advocate Alice, the 2010 Constitution was termed as a great milestone when it comes to electoral justice, to the extent that different political players can be able to have the confidence of seeking electoral justice in the Supreme Court. But before you even talk about Supreme Court and any other court in terms of handling electoral disputes, as a country, we had a dark period before we came up and said as a nation, we need to have structures. Can you take us through how we came to that particular point of agreement?
Thank you very much. We already stated what happened in 2007, and we saw that so many lives were lost. So many people became IDPs. They lost their homes, they lost properties. And the country could not just sit back and watch this and wait for another 5 years to come and we go through the same process. Mm-hmm. As we were told, we had already started attaining a mileage in political space. And so we see, after the atrocities that took place in 2007 and those loss of life, we see the government taking a step, and so many commissions were appointed, but two of them that I can quickly recall was the Kriegler and the Waki. Yeah. They came up with reports, and all those reports pointed out to the structures, lack of structures, and the problem that was there with the ECK, that is the Electoral Commission of Kenya. And they recommended that we come up with the IEBC, that we come up with a constitution. We change the constitution so that it marries all those recommendations that they were coming up with. And both commissions noted that we needed a simple, a fair, a free, a credible, a transparent, a verifiable election, which was not happening at that time. And that we needed to have laws that specifically state who can challenge, who is this who can challenge, and on what basis can we challenge a presidential election, so that we do away with the way presidents were being taken like small gods. Yeah. And that is when we see the Constitution 2010 being promulgated, and it came up with a lot of changes, which we are going to discuss in a while.
All right.
Yes.
Now, Advocate Lungwe, when we're talking about structures and how the 2010 Constitution, give us a milestone in terms of creating structures, we get into the context of 2013 and 2017 presidential petition, and in specific, 2017 presidential petition that was termed historic, given that a Supreme Court, a six-judge bench, invalidated elections here in the country. Now, take us through how courts have been empowered to the extent that they can invalidate something that has been done within, election is not an event. They say it's a cycle of an election during that particular election.
Yes, picking from where you have left, election truly is not an event, and as it was pointed out by the court in the last presidential petition of 2017, election is a process, and it begins all the way from the registration of voters, preparation of material, even procurement, before registration. From procurement all the way to registration of voters, all the way to confirmation, and then come to elections, and all the way to declaration. So it's an entire process. And if you look at the way the two presidential petitions have been handled, in my very humble assessment, I regard both to be historic. You see, presidential petition is not just historic because elections have been nullified. It can be historic because elections have been affirmed.
Right.
And there are clear reasons why
the election
has been affirmed. But if you look at the way the election petitions were handled, particularly of 2017 and 2013, you realize that our court had now acquired some muscle, some legal muscles and standing. At least they could stand on their feet and make some bold declaration, as opposed to the way things used to happen previously. And that one speaks to the infrastructure that the Constitution and the framers of the Constitution had created, and the political goodwill that people exhibited and decided to give to the judiciary. Because you see, you can have a very good law, very excellent Constitution, but if players in this political space and in the legal space are unwilling to support it, judiciary, then judiciary can't do much.
Sure.
So if you look at the way our Constitution is structured, for example, judiciary was bolstered in terms of in terms of hierarchy. Initially we had the High Court and the Court of Appeal, but now under the new Constitution we had 3 tiers. Yes, so that we have the High Court, the Court of Appeal, and the Supreme Court. Previously, election petition, for example, challenging presidential election, was just regarded like any other petition suit. But right now, it's a very distinct and standalone suit, so to speak, with the separate timelines, separate rules and procedure. For example, there is no any other case or petition in this country whereby the law requires that it be determined within 14 days, except presidential petition. So if you look at all those legal muscles that were given into the law and into the institution, you realize that it's out of all those things that we are able to be where we are. And we are able to make those historic declarations like the one we had.
Just to add something.
Yes, please.
The judges now feel, they have their space because of the competitiveness in hiring judges. You don't just get there. It used to be, do you have somebody in the village there who comes from a given village so that we balance, or they are singing the tune of the sitting president. So you just come. If you are a lawyer, you are just appointed. But now it is competitive. You go through a rigorous process, and that is why somebody can be able, to stand and say this election is not proper.
And perhaps the 2010 Constitution, why did it create a 3-tier sort of judiciary? And in specific, they said the Supreme Court is to handle presidential petition, when previously it was the High Court. Why did you have that particular juncture from the High Court to the Supreme Court, and the verdict by the Supreme Court is final?
Thank you. As I told you, we have come a long way. I was dealing with the history. Prior to the Constitution 2010, those structures that we were talking about, cases could be filed in court petitions, and they mark time there. They did not have timelines that he has spoken about, so that an election is being nullified like 2 weeks to another election. Applications could be brought, counter applications, and the incumbent, whoever was declared the winner, could make sure that they stifle the system so that they are not removed from office. It happens, you find 2 weeks to or a week to, that is when a decision is coming up. And so part of what was being addressed is this, like what you saw, technicalities, is something that is addressed very well in the Constitution.
Yeah.
And Article 159 of our Constitution, you cannot throw any other case out just on a technicality.
Sure.
You have to be really, really certain that you have to bring out reason. You have to convince the courts why this should happen. And so that is why, because of this, we had to amend our constitution so that we have a special court that just deals with presidency. And that is when we came up with the Supreme Court, so that the High Court as the original jurisdiction to deal with all these other petitions. If a member of parliament is challenging an election of a certain member of parliament, then they go to the High Court. Women rep, all those, and the magistracy deals with the MCAs, okay? So that the Supreme Court deals with the presidency, and we have timelines within which they have to deal with those petitions.
All right. Now, when you bring the conversation to what is happening right now,
yes.
In the 2022 presidential petition, the court has a timeline of 14 days. And we saw what happened. We are on the 8th day, and between the first day and the 7th day, we saw the petitioners and the respondents come to court with evidence in lorries, voluminous affidavits, and the 7-judge bench has to sit down within the days stipulated, that is 14 days, to hear the petition. Advocate Lungwe, when it comes to the timelines, and given that in 2017 we only had 2 petitions, in this particular 2022 presidential petition, we have 9 petitions, but 2 were removed today, so we have 7. So the timelines, 14 days, is it enough to listen to these petitions, given the magnitude of the evidence before the court?
I believe if you are to look at it from academic perspective, you would say that it's not enough. But if you are to look at it from the magnitude of it and the history that we have had, and I'm very glad my senior has clearly explained the issue of people coming in with the technicalities to delay, the issue of filing a petition and it stays in court for 3 years, 4 years, towards the end of that cycle, that's when you get a decision. We wanted a court which could expeditiously deal with this matter, given the magnitude of it and the emotions attached to it. So if you were to ask me, I would not even recommend amendment of any law to extend that period is enough. What we need is that we need men and women who are equal to the task. For example, I will give you a very nice example today. And yesterday, because the Supreme Court has made some fundamental rulings which would go along the way ensuring that the matter is, they get as quickly as possible to the real issues and the matter is expeditiously disposed of. There was some part of the petitions which were thrown out. They were touching on some other things which were considered to be on the periphery, sideshows, whether that petition should be thrown out or not. And if you look at the mandate of the court is probing into a very straightforward issue, whether the president-elect was validly or not validly elected. So if you were to come in with other sideshows to clog the system, the court will tell you no. Another thing which is a very important development, you realize that these other courts, we have some people we call interested parties.
Amicus.
Amicus.
Oh, the friends. Oh, yeah, the interested parties.
Interest parties are people who come to claim that we have been mentioned or something of that kind, or we are also in another way involved. In 2017, the Supreme Court, just going along the way, ensuring that they render a well thought out decision within the stipulated timeline, they passed regulation, which we call the Supreme Court Presidential Election Rules. And the rules, which I'm glad that they have enforced today, they say that it is strictly disallowed. Any application that you put in seeking to be enjoined in presidential petition, it will be thrown out. If you have an interest, file the petition within 7 days. And that's why you have seen a number of parties, including the Honorable Mwaure, who had contested, had made an application to be enjoined as an interest party, but the application was disallowed. Those are some of the mechanisms that the court is trying to put in place to ensure that they capitalize and they maximize on the strict timelines that they have, so that they render a decision that is well thought out and a decision that is quick to address the situation at hand.
Yeah.
Yes.
Thank you, Advocate Lungu, for that particular perspective, and it brings the discussion of the issue of interlocutory application. I think today Kenyans were treated to that. Interlocutory application is a legal, sort of a legal term that many want to understand what it is about. But before we debunk what it is, what we saw in the court today in terms of the 7-judge bench making ruling concerning IEBC, what they will allow in court, this petition has been thrown out. What Advocate Lungu has said in terms of petition that did not touch in Article 140 of the Constitution in terms of presidential elections outcome. Interlocutory application, are they the standard point as to which the court sort creates a judicial hygiene, so to speak?
Thank you very much. When it comes to litigation process, you don't just jump into trial. If you jump into trial without dealing with some of those issues, like he was talking about sideshows, you will be in trouble. And the starting point in any litigation, even if it's not a petition, it is taking directions, and that is what was being done. Now, during those directions, the term interlocutory, like it goes, it is in between the trial of those petitions and the starting point. So once we have taken directions, we deal with these applications. There are people who want to bring in more evidence. There are people who want to be joined as amicus curiae, like he has said. There are people who want to be joined as interested parties. So it is up to the court to listen to all these applications so that we are not derailed when we start dealing with the hearing of the petition, so that we go direct to the petition, we deal with all these, those are the interlocutory applications. In between, interim applications, they are supposed to be dealt with. Whoever is supposed to come in as an interested party, amicus curiae, anything, any application, you want to bring in some evidence that had been left out, like we saw in 2013. There was an affidavit that had voluminous information that was thrown out because it came in late. But in 2017, we see them ironing that. If it will help the court to do justice, then it is going to be entertained. And so if you have such applications, you bring them at this point. You don't raise them at the point of trial of the petition. And that is where we lost the point previously. Applications could come in. The day we are coming for the petition, somebody files an application like yesterday. So that today when we are supposed to do the petition, he says, I have an application. I filed an application yesterday, which I believe Your Honor should be given, should be heard first. And that really derailed. That really wasted a lot of time. We could not finish within the timelines. And this is what the Constitution was seeking to address, to have timelines, to deal with any sideshows, like he was calling them.
Just to add, because there is something which is very important and is happening currently, and it doesn't really touch on the merit of the suit, but it happened. You see, immediately the court rendered its ruling today, a number of rulings actually, on the pre-trial, the arrangements and everything. There is this presidential candidate, Professor Wajakoya, who stood up.
Yes, to get to that.
It goes to what the senior is talking about after the close of pleadings and those issues have been settled, we are focusing on hearing. If you come up with anything, it will be thrown out. And that's why you could see those who are watching could see, despite the fact that he was a candidate, he was silent and he was told, you wait, we read out the ruling, then you can raise those issues, but we have already done with the pre-trial, so we are not going back. And that's how it's supposed to be.
All right, and to touch on that, why does the court not allow just anyone to be enjoined as an interested party or an amicus curiae in these particular cases? In the case of Maori and also other litigants who have wanted to be joined as friends of the court?
It's the main reason is, in my very humble view, is time factors.
Time factors.
Yes,
All right.
this is a very voluminous petition touching on issues of serious magnitude. So if you are really interested in it, come as a petition.
Okay.
Or come because you have been sued as a respondent. But if you see people fighting, there is a time frame for people putting in papers, you are sitting on the fence, and now everything has been put in place, things have become popular, and now you want to sneak in and also be heard, and perhaps capitalize on that platform and audience, the court will tell you no. Because I can tell you for sure, despite the fact that we are having, our judiciary is still struggling, but those 7 men and women are equal to the task, and you could see even the seriousness of the questions that they're posing and the depth of the answers they're giving. Sometimes you can even make an application argues and they give you the ruling straight away, which is well reasoned. So they are very serious. They will not entertain any, so to speak, jokers.
Yeah, well put. All right, now we'll be taking a short break. That was the part of speaking about the 2010 Constitution and how it has helped petitions, especially in the 2013 and 2017 presidential petition. Once we get back, we'll be looking into the 2017 and 2022 presidential petition and how we'll be moving forward as a country in terms of the issues that have been sought in that petition. Stay with us.
KUTV, in conjunction with Kenyatta University Funeral Home, is now offering death announcements immediately following on news bulletins at 7 p.m. At this sorrowful time, as you share in your grief, allow us to communicate your announcement of your loved one on KUTV in both Kiswahili and English. For more details, kindly inquire at the KU Funeral Home Service Desk or call 0736 928 380 or dial 020-359-9054.
Driving and riding without incidences on the road is such an amazing experience. But do you know while many road traffic crashes are avoidable, human behavior continues to be the leading cause. Speeding, lane indiscipline, drunk driving, distracted driving, failure to wear a helmet, and failure to use available pedestrian ways have been flagged by NTSA as the fatal 6 behaviors likely to lead to a fatal crash and serious injuries. As part of the Usalama Barabarani campaign, we request all road users to prevent these fatal 6 behaviors for their own safety and that of others. When driving, ensure your speed is within the stipulated limits. The road ahead is clear before overtaking. Stick to your lane. Keep left unless carefully overtaking. You're well rested if driving on long distances, and you never drink and drive. Usalama Barabarani starts with you. Fika Salama. This message is brought to you by the National Transport and Safety Authority and the European Union.
Do you think the circus of leadership, the Prime Minister position, the other MPs that are set to get in there under the BBI document, is it right?
It is. One thing you need to understand, Max, when you're having a big company and you want management to be at par, you want to succeed, you need to involve more people, you need a lot of workforce. And so the BBI introducing more leaders, we are having few leaders right now as a country, and you see how much we are losing.
Many thanks indeed for staying with us. This is Law Matters. My name is Irene Wangi, standing in for Dr. Ngugi Kingara, and we're talking about election petitions. And before we went on the break, we were seeking to know how we have moved as a country in terms of the issues of the 2017 presidential petition and now the 2022 presidential petition, without looking into the merits and the demerits of that particular case. With me is Advocate Alice and Advocate Lungwe, who are giving me a perspective and helping our viewers to understand what is happening here in the country. Now, Advocate Alice, when we look into these particular petitions, and when Azimio la Umoja One Kenya presidential candidate was filing the petition, many electoral experts or legal experts were saying it was not in vain. Whether they uphold or invalidate the victory of President-elect William Ruto, the country will have made strides in terms of the conduct of elections. So tell us, there's several petitions that have been filed between 2013 and 2017 after the 2010 constitution, how they have helped create procedure on how electoral bodies conduct elections here in the country.
Thank you very much. When we look at, we have already spoken about the constitution, and we have already said that under Article 140, now you can challenge the victory of a president declared elect.
Mm-hmm.
When we look at what happened in 2013, we come to 2017. There are certain conducts that were carried out in 2013, and in 2017, the Supreme Court improved on its own, or went against its own decision in 2013.
Mm-hmm.
When we look at 2013, one standing out issue that I mentioned is that one of the petitioner then, Raila One, said that their evidence was locked out.
Mm-hmm.
On still the technicality that we are fighting about.
Yeah.
And this evidence was a huge, voluminous affidavit that contained a lot of information.
Mm-hmm.
And people were feeling like, had the court looked at that, maybe the decision could have been different.
Mm-hmm.
So in 2017, we see the courts looking at what we call in civil litigation the overriding objective. The courts are trying to look at the merits, trying to factor in expeditious disposal of cases. But even if we want to look at cost, we want to look at time, we want to look at all this, we must make sure that justice is done. And so the cry that was there, that in 2013, that evidence was just thrown. In 2017, we see them relaxing a bit, but again getting, trying to make sure that they are on course. They don't deal with sideshows like we earlier stated. And we have seen that electronic transmission of results was introduced in the current election because that is what was pointed out. And all along, Chebukati was saying we are trying as much as possible to make sure that we adhere to the findings of the 2017 court on that presidential election. So they tried as much as they could. So let's see whether they really did it to the expectation or to the expectation of the law.
Advocate Lungu, let me now look into the issues that we're having right now. In 2017, it was IEBC as a commission, they had violated the laws in terms of the conduct of the elections. But now in 2022, we are not only talking about a divided commission, we are now asking the question of what is the role of IEBC, what is the role of the chair, the commission itself. Looking at now how far we have come, do you think we are stretching the Constitution in terms of understanding it, that even though Article 138(10) of the Constitution is clear, we still need the court to pronounce itself on the conduct of the commission, the commissioners and the chairperson?
Yes, we are doing exactly that, and that's a good thing, because earlier you talked about case law. There is something, case law, we call it now, in technical terminology, we call it jurisprudence. So there is that law that develops. You see, the Constitution, we say that the Constitution is a living document.
It is.
And the judiciary is the primary actor, or the primary person that breathes life into the Constitution. So the more we litigate about the provisions of the Constitution, the more we develop the law, the more we develop the jurisprudence as a whole. So if you look at the way our courts have handled this petition, there has been a systematic improvement. For example, in 2013, something that really came out and which we had never considered so much is the question of to what level do you need to persuade the court so that they can grant what you are seeking? See, now in legal terms, we talk of the standard of proof.
Okay.
You see, in election petition. So the court was confronted with that question, asking itself, what amount of evidence, if you were to quantify it, should a petitioner present for us to be able to agree with the petition? And the court settled that. Another thing that court looked at into, which was also, we didn't really apply our mind properly before those cases came up, was the question of, for example, of rejected ballots. Because if the Constitution says that a person will garner 50% plus one of the vote cast, what is the meaning of the vote cast? You see, now in the Constitution, when you are reading it, for example, for academic purposes, you just read, I know the Constitution says 50% plus one of the vote cast. But when it comes to the question now of the law and interpretation and application, the court will ask yourself, what is the position of rejected ballot? Somebody walked into a booth and put a tick on two candidates. How do you handle that ballot paper, for example? So the court had to come in and clarify that. And now you realize that coming 2017 and even this one, at least we are somewhere. We have improved. Coming, for example, to the issue of how the election is supposed to be, votes are supposed to be tallied, computed, and relayed. You see, initially the Constitution was self-speaking. You could say the 2010 Constitution says election should be transparent, fair, credible, and blah blah, all those nice words. But we did not get into deep understanding of how these votes are supposed to be relayed. And that's why now the aspects of servers are coming in, the aspect of Form 34As, now people being conscious about it. You see, all those are developments that you're witnessing courtesy of the law that was developed by our courts.
Yes.
So we have had that improvement.
All right. Now, Advocate Alice, what happened in the courts today is that they created what we call issues that they will deal with. And we have now, we're talking about 8 issues plus 1, which is the outcome. Talking about why they put them into issues and why we have to consolidate the cases, because we had 7 petitioners, but now they have been consolidated into 1 petition. Why does the court use that particular methodology in terms of hearing these particular cases?
Thank you very much. In litigation process, once again, we spoke about taking directions. That was what was being done today. And why they came up with 8 issues, those are the main questions that the court is supposed to answer. Otherwise, if we were to leave it open so that I come, I say what I want, another one says what they want, they may not complete this within the timelines that have been provided under the Constitution. So specifically, we are not going to go outside that. Even the petitioner is going to address this, the respondent is going to respond to that. They are not supposed to go outside the questions that are there. And even the rulings are going and the judgment, they will just follow those questions. Those are the pertinent issues that are supposed to be addressed, and anything outside there can be easily challenged if it were moving from maybe a lower court to a high court. So it's up to you to make sure that if you are talking about nullifying that election by the end of, that is the next thing you said, the outcome. In the case of Gatirao, Peter Munya, the courts were very, very specific that by the time you nullify an election, the evidence that you're giving should be so strong that
standard of proof, they say?
Yes, the standard of proof is not beyond reasonable doubt, but it's between balance of probability and beyond reasonable it has to be in between there, not beyond reasonable doubt. Beyond reasonable doubt is when we are dealing with criminal cases. Civil cases on a balance of probability. For these elections, it is in between there.
All right. Now, in 1 minute, Advocate Lungwe, when it came to the drama witness where Chebukati said they met with so-and-so at the specific place and what, which the court did not put into the 9 issues, what happened to those sort of, evidences affidavits being filed in court? In just 1 minute, as we finalize.
You see, an affidavit is simply a vermin under oath, and everything indicated there is not necessarily true until it's tested and proved to be true. And again, another thing you need to understand is that the issue do not necessarily just emanate from affidavit at all. It's, for example, a catalogue of documents which have been filed. So even the issues that were raised in those affidavits have been subsumed by the 9 issues which have been crystallized by the court. So the court cannot say this one we are lifting from the affidavit of Chebukati, but it will enumerate issues of which it knows that upon determination of those issues either way, they will make either determination.
All right. Thank you so much, Advocate Alice Mungaro and Advocate Jackson Lungwe, for making time and giving us a perspective in terms of election petition here in the country. I know the time was really, small in terms of interrogating each and particular petition that we have had here in the country during that particular time frame, but maybe next week when the Supreme Court will have determined that particular petition, we'll be having more discussion concerning that.
Thank you.
Thank you so much. Thank you. All right, that has been Law Matters today, talking about election petition, what it is we are facing at the country at the moment, what is the jurisprudence of that particular electoral petition, and how far we are coming as a country in terms of seeking electoral justice here in the country. Thank you for your opinion, comments on our social media platform. My name is Irene Mwangi, standing in for Dr. Ngugi King'ara here at Law Matters. Thank you so much for watching. Have a splendid night.